Hi everyone, welcome to the Basic Philippine Law and Jurisprudence channel. This is the series of lectures on property and land laws. Our topic for today is usufruct. What is usufruct? Article 562 tells us that usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law provides otherwise. In other words, from the name itself, usufruct, uso meaning use, and fructo meaning fruits. So usufruct is the right to use as well as the fruits. Okay? It is the right to enjoy the property of another temporarily, including the right to use and the right to the fruits, with the owner retaining the right to dispose or the power to alienate or encumber the same. In other words, what is being given in usufruct is the right to use or enjoy the thing, as well as the right to enjoy or to receive the fruits. However, the right of ownership or the dominion or the power to alienate or to encumber the property is retained by the naked owner. What is being given to the usufructuary is only the right to use or to enjoy the thing in usufruct, as well as the right to receive the fruits of the thing in usufruct. Okay, now what are the characteristics of usufruct? It is a real right of use and enjoyment because it normally attaches to real property. It is a real right to use and enjoy the property. It is only of temporary duration. There can be no perpetual usufruct. It is always temporary. It is number three, it is transmissible, meaning you can transmit it to another person or you can assign it to another person. You need not be the one to personally enjoy or use the property. You can transmit or assign the enjoyment or use of the property to another person. Number four, it may be constituted on real or personal property. So real property is normally the object of usufruct, but it need not always be real property because there can always be a usufruct on personal property. It may be also constituted on either a consumable or a non-consumable, although a usufruct on a consumable is normally uh, what is known as an abnormal usufruct. Okay, because normally a usufruct is constituted on a non-consumable thing because there is always an obligation to take care of the thing in usufruct and to return the thing in usufruct to the naked owner, uh, of course subject to the deterioration on normal wear and tear of the property. It may also be constituted on tangible or intangible property. Okay. As I was saying, okay, the obligation of the usufructuary, one of his obligations is to preserve the property given in usufruct, with the exception of an abnormal usufruct because it involves consumables. Consumables, as we all know, okay, we have to make use of the thing. And by using the thing in usufruct, you destroy it. Okay, so there is the obligation of returning the same thing which is given in usufruct is an impossible, it's an impossibility. Okay, so in such cases, normally what we do is you determine or appraise the value of the thing at the beginning of the usufruct because that value would be the one that you would return to the naked owner, or you return the thing of the same kind and quality at the termination of the usufruct. So usufruct is constituted by law. by the will of private persons expressed in acts inter vivos or in a last will and testament and by prescription. So these are the modes. Article 563 tells us about the modes of creation of usufruct. So it may be by law. There is a legal provision which constitutes the usufruct. Will of private persons, meaning it is voluntary, by contract or by last will and testament, meaning succession, and by prescription. Usufruct also, there are different kinds of usufruct which are laid down under Article 564. It may be constituted on the whole or part of the fruits of the thing. When you say whole, a usufruct may be constituted on the entire patrimony of the naked owner, meaning his entire properties. Or it can also be constituted on a part thereof. So in favor of one or more persons, so usufruct may be either simple if it is constituted only in favor of one person, or there can be multiple usufructuaries. In such cases, there can be rights of accretion among usufructuaries, simultaneously or successively, and in every case from or to a certain date. There can also be a usufruct with a period, the period of which may be either pure or the condition may be either pure or it may be resolutory. So, uh, the rights and obligations under Article 565 of the usufructuary shall be those provided in the title which constituted the usufruct. So if there is a contract, then the obligations of the usufructuary will be those embodied in the contract. Now, what if there is no written contract? The provisions contained in the Civil Code on usufruct will govern their rights and obligations. As I've said, the classification of usufruct may either be legal because it is constituted by law, it may be voluntary or by contract, and it may be by prescription. There are different kinds of usufruct. They may be total, constituted on the entire patrimony of the naked owner, or it may be partial, constituted only on a portion or a specific item which belongs to the naked owner. It may be simple without any condition or constituted in favor of one person, or it may be multiple, constituted in favor of two or more usufructuaries. It may be pure without any condition, okay, or it may be with a term which may be either suspensive or resolutory. So when we speak of a resolutory condition, the happening of the condition terminates the usufruct. When we speak of a suspensive condition, the happening of the condition gives rise to the usufruct. It may be constituted over things, okay, tangible objects, or over rights. Okay, we now go to the case of Alcantara versus Reta. Okay, so in this case, the basic issue that was resolved by the Supreme Court is Reta a lessee or is he a usufructuary? So the Supreme Court in this case stated that Reta is a usufructuary because respondent Reta allowed the petitioner Ricardo Roble, to use the 62 coconut trees for 186 from where he gathered tobacco. So this arrangement would show that it is a usufruct and not a lease. Usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance, unless the title constituting it or the law provides otherwise. In this case, petitioner Roble was allowed to construct his house on the land because it would facilitate his gathering of tobacco. This would be in the nature of a personal easement under Article 614 of the Civil Code. Okay. We now go to the case of National Housing Authority versus Manila Seedling Bank. So in this case, petitioner, meaning National Housing Authority, is the owner of a large tract of land, okay, in the center of Quezon City. Now, the former President Marcos reserved a 7-hectare area and gave it to the respondent Manila Seedling Bank. Okay? The kind of rights that were given to Manila Seedling Bank were usufructuary rights. So the right to use as well as to the fruits of that 7-hectare portion. Again, in this case, the court uh, defined the usufruct as a right to enjoy the property of another with the obligation of preserving its form and substance. Respondent, for its part, must vacate the area that is not part of its usufruct because it exceeded the 7-hectare area that was given to them in the usufruct. The case of Alunan versus Veloso, this case involves abnormal usufruct. Can there be a usufruct over consumable things? Because one of the obligations of a usufructuary is to preserve and to take care of the thing in usufruct with the diligence of a good father of the family. So considering that obligation, can usufruct be constituted over things which are consumable, meaning those things that cannot be used without being consumed? The answer is yes. So in this case, the Supreme Court said that since the widow's right is only a usufruct, and as there can be no usufruct of money, since it is a fungible thing, the adjudication made to the widow was erroneous. It is incorrect to say that there can be no usufruct of money because it is a fungible thing, because there is such a thing as an abnormal usufruct. Okay. So, as we already know, usufruct means the right to use and enjoy the thing in usufruct, as well as the right to receive the fruits. So let us first discuss the right of the usufructuary to the fruits. Article 566 tells us that the usufructuary shall be entitled to all the natural, industrial, and civil fruits of the property in usufruct. With respect to hidden treasure which may be found on the land or tenement, it shall be considered as a stranger. So there are, as you all know, there are three kinds of fruits: natural, industrial, as well as civil. Now, with respect to those fruits, during the period of the usufruct, he is entitled to receive those fruits. However, with respect to hidden treasure is not considered as a fruit. Hidden treasure belongs to the naked owner because it is considered as part of the principal, as part of his surface rights. So with respect to hidden treasure, since it is not considered as a fruit, he is considered as a stranger. But he will be entitled to one half thereof if he finds the hidden treasure, because he is allowed to be in the property by virtue of his right as a usufructuary. So he will share half thereof to the naked owner of the property. Okay. So Article 567 tells us that natural or industrial fruits growing at the time of the usufruct begins belong to the usufructuary. Those growing at the time the usufruct terminates belong to the owner. Okay, so with respect to those fruits which are growing at the time of the commencement of the usufruct, okay, the usufructuary is not obliged to reimburse the owner of the expenses, okay, that he incurred in producing those growing crops. But if uh, the usufructuary at the time of the termination, the usufruct has growing fruits on the property. Okay, the naked owner has to reimburse the usufructuary of the expenses that he incurred. Why? Because when the naked owner at the commencement or at the beginning of the usufruct left growing fruits, knowing that he will give it in usufruct to another person, then he is not expecting to be reimbursed. While when the usufructuary, on the other hand, okay, expended money, okay, and then at the termination of the usufruct, okay, there are growing crops, okay, then the naked owner should reimburse the said expenses. Okay. How about with respect to civil fruits? Civil fruits are deemed to accrue daily. Okay? And they belong to the usufructuary in proportion to the time that the usufruct lasts. Okay? So during the period, the entire period of the usufruct, the civil fruits that would accrue during the said window will be received by the usufructuary. So whenever a usufruct is constituted on the right to receive rents or periodical pension, whether in money or in fruits, or in the interest on bonds or securities payable to bearer, each payment due shall be considered as the proceeds or fruits of such right. Because civil fruits, they accrue daily. Okay, so it is very easy to compute the civil fruits that are due to the usufructuary because they accrue daily. Okay. Now we go to the right to use as well as the right to accessions. So we have already previously discussed the right of the usufructuary to the fruits. Now we move to the right of the usufructuary to use and enjoy the property in usufruct as well as to enjoy the accessions of the property in usufruct. Article 572 tells us that the usufructuary may personally enjoy the thing in usufruct, lease it to another, alienate his right of usufruct even by a gratuitous title, but all the contracts he may enter into as usufructuary shall terminate upon the expiration of the usufruct, saving leases of rural lands which shall be considered as subsisting during the agricultural year. Okay, remember one of the characteristics of a usufruct is that it is transmissible. Okay, the usufructuary need not personally enjoy or use the property. He may even sell the right of usufruct to another person, or he may even donate it by gratuitous title. Okay, or if he wants, he may lease it to another person. Okay, but all of which must be within the period of the usufruct. Okay, um, Article 571 tells us that the usufructuary shall have the right to enjoy any increase which the thing in usufruct may acquire through accession, the servitudes established in its favor, and in general all the benefits inherent therein. Okay, so if there are accessions to the property, like for example, in cases of lands, if the land, by virtue of the accretion, okay, has increased its area, then the usufructuary has the right to enjoy it. Okay, and easements or servitudes established in favor of the property in usufruct. The usufructuary can also enjoy. Okay? Article 573 deals with the ordinary wear and tear of the property given in usufruct. So whenever the usufruct includes things which without being consumed gradually deteriorate through wear and tear, the usufructuary shall have the right to make use thereof in accordance with the purpose for which they are intended, and shall not be obliged to return them at the termination of the usufruct, except in their condition at that time. But he shall be obliged to indemnify the owner for any deterioration they may have suffered by reason of fraud or negligence. The degree of diligence that is required of a usufructuary is diligence of a good father of the family. So he has to take care of the thing in usufruct with the diligence of a good father of the family. So whenever there is deterioration of the property brought about by wear and tear, then he will not be responsible for the same. Obviously, especially if the usufruct has been constituted for a number of years, the property in usufruct will eventually deteriorate. So in that case, if it is brought about by ordinary wear and tear and not brought about by the fraud or negligence of the usufructuary, he will not be held responsible for it. He will not be held accountable for um, returning the property not in the same condition as it was given during the beginning of the use of law. Okay? Article 574 tells us that whenever the use of rock includes things which cannot be used without being consumed, the use of proctory shall have the right to make use of them under the obligation of paying their appraised value at the termination of the use of rock. If they were appraised when delivered, in case they were not appraised, he shall have the right to return the same quantity and quality or pay their current price at the time the use of rock ceases. So Article 574 deals with abnormal use of rock. So even consumable things or those which cannot be used without being consumed, okay, can also be the object of use of rock. So the obligation of the use of factory in cases of abnormal use of rock is to return either the appraised value of the thing or to return the same kind and quality of the thing given in use of rock or to return their current value at the time that the use of rock terminates. Okay. Now we go to the special kinds of usufructs. There are special kinds of usufructs such as usufructuary of wood-bearing trees and usufructuaries of woodland. What is the obligation of a usufructuary of fruit-bearing trees? Okay, Article 575 tells us that the usufructuary of wood-bearing trees and shrubs may make use of the dead trunks and even those cut off or uprooted by accident, under the obligation to replace them with new plants. Okay, so those which fell, okay, by reason of accident or by reason of fortuitous events such as bad weather, okay, they can be used by the use of fracturing with the obligation of replacement. Okay? If, for example, as a consequence of a calamity or extraordinary events such as a typhoon or such as, let us say, forest fire, the trees or shrubs shall have disappeared in such considerable number that it would not be possible or it would be too burdensome to replace them. The use of fracturing may leave the dead, fallen, or uprooted trunks at the disposal of the owner and demand that the latter remove them and clear the land. Okay, remember we are talking here of fortuitous events, extraordinary events which are not brought about through the fault of the use of fracturing, in which case he is not under obligation to replace them with new plants. Okay, he may just leave them or demand that the land be cleared. Okay, now let us go to the use of fracturing of woodland. Okay, the use of fracturing of woodland under Article 577 may enjoy all the benefits which it may produce according to its nature. So if the woodland is a copse or consists of timber for building, the usufructuary may do such ordinary cutting or felling as the owner was in the habit of doing. And in default of this, he may do so in accordance with the custom of the place as to the manner, amount, and season. Remember that the usufructuary of woodland, in a usufructuary of woodland, the wood or the trees that will come from the wood that will come from the trees is actually the fruits. Okay, so he, the owner, the habit of the owner in the cutting or felling of trees, okay, is the one that is acquired by the use of usufructuary because he is entitled to the fruits, and the fruits thereof would be the wood coming from the trees. So in any case, the felling or cutting of trees shall be made in such a manner as not to prejudice the preservation of the land. In nurseries, the use of rockery may make the necessary thinnings in order that the remaining trees may properly grow. With the exceptions of the provisions of the preceding paragraphs, the use of rockery cannot cut down trees unless it is to restore or improve some of the things in use of rock. And in such a case, he shall first inform the owner of the necessity of the work. Okay? Article 578 tells us of another special kind of use of rock. It is the use of rockery of the a right um, for to bring an action to recover real property. Okay? So in this kind of use of rock, he has the right to bring the action as well as to oblige the owner to give him the authority and to furnish him whatever proof he may have. If, as a consequence of the enforcement of the action, he acquires the thing, the use of rock shall be limited to the fruits, the dominion remaining with the owner. So he was given the right to bring an action to recover real property. Now, if he succeeds, then his right would only be limited to the fruits as well as the enjoyment or use of the property. The naked ownership will still remain with the owner. Okay, Orozco versus Araneta. Orozco died leaving a will. Uh, the pertinent clause of that will provides that certain property should be given in life use of right to his son Jacinto, okay, with the obligation on his part to preserve the said properties in favor of the other heirs who were declared the naked owners thereof. So the use of rock is Jacinto. Now the naked owners are the other heirs. Now Benguet, Consolidated Mining, declared stock dividends out of its surplus profits. Now, the question or the basic issue in this case is whether the stock dividend is part of the capital, which should be preserved in favor of the owner, or an income or fruits of the capital. Okay, so because if it is considered as a fruit, then the usufructuary is entitled to it. If it is considered to be part of capital, then it is the naked owners which is entitled to it. So a dividend, the Supreme Court said that a dividend, whether in the form of a cash or stock, is income and consequently should go to the usufructuary, taking into consideration that a stock dividend as well as a cash dividend can be declared only out of the profits of a corporation. So it is considered as a civil fruit, and therefore the usufructuary is entitled to it. The case of De Albar versus Carandang. In this case, Doña Rosario was the owner of a lot with a building and improvements thereon. So by a will left by her upon her death, She devised the naked ownership of the whole property to Gray, but its usufruct to Fabi or Light. So she divided the naked ownership belonging to Gray and the usufruct belonging to Fabi. However, the building on the lot was burned. So a Chinaman who is leasing the property offered to lease the property for a period of 5 years, agreeing to construct on the lot a new building, provided that the naked owners as well as the usufructuary sign the agreement. So Gray started this case to settle the dispute and conflicting views entertained by the parties. Petitioners contend that the provision of the will should be interpreted as constituting only a life usufruct on the rentals of the buildings erected on the land, and that once these buildings are destroyed, the usufruct is extinguished. So, by the fact that the building was burned, okay, does it mean that the usufruct is already extinguished? Respondent, on the other hand, contends that the provision should be interpreted as constituting a life usufruct both on the building as well as the land, because the former cannot be separated from the latter. Okay, so in our opinion, the Supreme Court said if the usufruct is constituted on an immovable property of which a building forms part, and the latter should be destroyed, the usufructuary shall have a right to make use of the land as well as the materials. Since the usufruct has not been extinguished by the destruction of the building, and the usufruct is for life, as in this case, it is but fair that the usufructuary continue to enjoy the use of the land and the materials that may have been left by the buyer, or to the use of the new building that may be constructed on the land. So the fire which gutted the building did not extinguish the use of rock on the sea, because the land as well as the materials left from the fire may still be used by the use of rock. Okay? We now go to the case of Lopez versus Constantino. Appellant sold to her daughter a parcel of land with buildings and improvements. So the sale was subject to the condition that the vendor will receive from the vendee by way of life pension one half of the rents. However, the building was totally destroyed by fire. So similar to the previous case of the Albar, in this case, the building from where the life pension is being sourced was destroyed by fire. So after the destruction of the building, uh, the our respondent contends that her obligation to pay the appellant a life pension was already terminated, because it is from the rents thereof from which said pension was sourced. Okay? When both land and building belong to the same owner, the rents on the building constitute an earning of the capital invested in the acquisition of both land and building. There can be a land without a building, but there can be no building without a land. The land, being an indispensable part of the rented premises, cannot be considered as having no rental value, since appellant's participation in the rents of the leased premises by way of life pension was part of the consideration of the sale. It cannot be deemed extinguished so long as she lives and so long as the land exists, because that land may be rented to anyone who may decide to erect a building thereon. So it is similar to the previous case. Policarpio versus Salamat. In this case, in her last will and testament, Namasa gave the naked ownership of a fish pond owned by her to her sister, while its usufruct to the children of her cousins. So there are all in all 14 usufructuaries. Okay, they lease the fish pond. However, during the term of the lease, some of the usufructuaries died. So upon their death, the naked owner and the remaining usufructuaries claim the shares corresponding to the deceased usufructuaries. So who is entitled to the shares of the deceased usufructuaries? The surviving usufructuaries are entitled to receive the shares corresponding to the deceased usufructuaries. The usufruct to continue until the death of the last usufructuary. Whether the 11 surviving usufructuaries are the ones entitled to the fruits that would have corresponded to the 3 deceased usufructuaries, or is it the naked owner? There is accretion among usufructuaries who are constituted at the same time when one of them dies before the end of the usufruct. The only exception is if the usufruct is constituted in a last will and the testator makes a contrary provision. So remember that in cases of usufruct and there are multiple usufructuaries, there is always accretion. Okay, so with respect to the deceased usufructuaries, their share, okay, will be accreted to the surviving usufructuary unless a contrary provision is stated in the last will. Okay, so should any one of them die, the share of the latter shall accrue to the surviving ones. These provisions of the will are clear. They do not admit of any interpretation. Okay, how about the improvements? Okay, if during the period of the usufruct, improvements were introduced by the usufructuary on the property. Okay, Article 379 tells us that the usufructuary may make on the property held in usufruct such useful improvements or expenses for mere pleasure as he may deem proper, provided he does not alter its form and substance. But he shall have no right to be indemnified therefore. So with respect to useful as well as to um, those improvements for mere pleasure or luxurious improvements, okay, the usufructuary, because he is the one who is enjoying or using the property, can introduce them, but he should not expect to be reimbursed. Okay, he has a limited right of removal if it is possible without causing damage to the property. Okay, there is always that implied limitation that whenever improvements are introduced, it should not alter the form or substance of the property in usufruct. Okay, the usufructuary also may set off the improvements against any damage he may have caused on the property. So the owner of the property, the usufruct of which is held by another, may alienate it, but he cannot alter its form or substance, or do anything which may be prejudicial to the usufructuary. Remember that in usufruct, the naked ownership, the dominion, or the right to alienate is still with the naked owner. So the naked owner can sell the property, but he cannot alter its form or substance or do anything which will prejudice the rights of the usufructuary. In other words, he must respect the right of the usufructuary and the term of the usufruct. Okay, although no one is preventing him from selling the property. Okay, provided that his rights, the rights that will be derived by the person who bought the property will be the rights of the naked owner, which has given the usufruct to another. Okay, Article 582 speaks of a property which is co-owned and which is also given in usufruct. So the usufructuary of a part of a thing held in common shall exercise all the rights pertaining to the owner with respect to the administration and collection of goods or interest. If the co-ownership cease by reason of the division of the thing held in common, the usufruct of the part allotted to the co-owner shall belong to the usufruct. Okay, the case of Reyes versus Gray. Is usufruct considered as a property? Well, Reyes versus Gray tells us that it is. A usufructuary interest in real property is not such an interest or right as can be sold under execution. That was the contention of the plaintiff's counsel, but the Supreme Court disagreed. The Supreme Court said the term property applied to lands comprehends every species of title, inchoate or complete, legal or equitable. This statute authorizes the sale under execution of every kind of property and every interest in property which is or may be the subject of private ownership and transfer. It deals with equitable rights and interests as it deals with legal without anywhere expressly recognizing or making any distinction between them. The usufructuary may, uh, if the usufructuary right is one which may be leased or sold, it must logically and necessarily follow that such a right is an interest in real property. It was the plaintiff's usufructuary right which was sold under execution. So a usufructuary right is considered as property. It is a real right. Okay, and therefore it can be the subject also of execution. Okay. Now let us now go. So we are through, we have finished, we have completed the discussion of the rights of the usufructuary to use, okay, to enjoy the property in usufruct, to receive the fruits, to enjoy the accessions, okay, as well as the obligation on the part of the right of the usufructuary to the improvements that he has introduced, if he can be reimbursed of the same, which legally he cannot have, but he has a limited right of removal. Okay? Now, let us go now to the obligations. What are the obligations of a usufructuary? Okay? Before he enters into the enjoyment of the property usufruct, he has an obligation to make, after notice to the owner or his representative, an inventory of all the property, which shall contain an appraisal of the movables and a description of the condition of the immovables. So, at the beginning of the usufruct, there is always that obligation to make an inventory. Okay, so if it is a movable property, you make an appraisal. If it is an immovable property, you describe the condition. Why? Because it is correlated with the obligation of the usufructuary to return the thing in usufruct in the same condition as it was received, save for ordinary wear and tear of the property. So if you do not make that inventory, okay, how can you be able to account for it at the end of the usufruct when the obligation to return arises? Okay, the second obligation is to give a security, binding himself to fulfill the obligations imposed upon him. So the usufructuary has to give a security. It is to assure the naked owner that he will perform his obligations while the usufruct subsists. Okay? The security will be sort of, will be the one to answer just in case the usufructuary fails to fulfill his obligation. Okay? Are there instances or cases wherein this obligations of making an inventory, of giving a security can be waived. Okay? Under Article 584, okay, the obligation to give a security will not apply to a donor who has reserved the use of the property donated. So if, for example, a donor has given by way of donation, inter vivos is the naked ownership of a property to another person. Okay, but he has reserved a life use of right over the same property. He need not give a security because it is at the height of ingratitude to require the donor to give security because it is by way of liberality he has given the property to the naked owner. It is at the height of ingratitude to even require him to give security. Okay? And of course, the obligation to give security is also not required with respect to parents who are usufructuaries of their children's property. So in those two cases, the requirement of giving security is waived. Okay? Article 585 tells us the usufructuary, whatever may be the title of the usufruct, may be excused from the obligation of making an inventory or of giving security when no one will be injured thereby. Actually, it is not obligatory on the parties. So if the naked owner is willing to waive the obligation of the usufructuary to make an inventory or to give a security, he may do so. Okay? Especially if there is no one which will be injured by the waiver of the same. Okay? Article 587 tells us that if the usufructuary who has not given security claims by virtue of a promise under oath the delivery of the furniture necessary for his use, and that he and his family be allowed to live in a house included in the usufruct, the court may grant this petition after due consideration of the facts. So instead of a security, the usufructuary will execute a promissory note or a promise under oath. Okay? The same rule shall be observed with respect to implements, tools, and other movable property needed for an industry or vocation in which it is engaged. If the owner does not wish that certain articles be sold because of their artistic worth or because they have a sentimental value, he may demand their delivery to him upon his giving security for the payment of the legal interest on their appraised value. Okay. Remember that these obligations, the obligation to make an inventory and the obligation to give security, unless they are excused, unless they are waived, or unless they fall within those exempt provisions of the civil code, okay, they are required before the usufructuary can enter into the usufruct, meaning before he can begin to use and enjoy the property as well as because after the security has been given by the usufructuary, he shall have a right to all the proceeds and benefits from the day which, in accordance with the title constituting the usufruct, he should have commenced to receive them. In other words, once this security and the inventory have been complied with, okay, he will enter into the usufruct and it will be retroactively applied to the day on which he should have received them. Okay? The usufructuary also shall take care of the thing given in the usufruct as a good father of the family. So, after giving the security, after making an inventory, he now has the right to begin enjoying the property as well as its fruits. But he has the obligation to take care of the thing in usufruct with the obligation of a good father of the family. Article 590, a usufructuary who alienates or leases his right of usufruct shall answer for any damage which the thing in usufruct may suffer through the fault or negligence of the person who substitutes him. Okay, so it is not a defense that he was not the one who damaged the property, because even if uh, the use of rock substitutes another person in his place to enjoy or use the property, any damage which is caused by his substitute will be answerable, will be answered by the use of usufructuary. Obligations for repairs or replenishment. Article 591 tells us that if the use of usufruct be constituted on a flock or herd of livestock, the use of usufructuary shall be obliged to replace with the young thereof the animals that die each year from natural causes or are lost due to the rapacity of beasts of prey. If the animals on which the use of usufruct is constituted should all perish without the fault of the use of usufructuary on account of some contagious disease or any other uncommon event, the use of usufructuary shall fulfill his obligation by delivering to the owner the remains which may have been saved from the misfortune. So just like in the case of wood-bearing trees and shrubs, as well as the wood stock, if it is due to a fortuitous event, okay, you will not be obliged to replace the said animals, but to deliver only what remains of the misfortune. Should the herd or flock perish in part, also by accident, and without the fault of the use of usufructuary, the use of usufruct shall continue on the part saved. Should the use of usufruct be on sterile animals, it will be considered with respect to its effects as though constituted on fungible things. Okay? With respect to repairs, it will depend on whether they are ordinary or extraordinary. Okay? With respect to ordinary repairs, the use of rock is obligated to make ordinary repairs needed by the thing given in use of rock. By ordinary repairs, what do they mean? Okay, they are required by the wear and tear due to the natural use of the thing and are indispensable for its preservation. Should the use of usufructuary fail to make them after demand by the owner, the latter may make them at the expense of the use of usufructuary. So minor repairs, ordinary repairs, those which are brought about by the normal use of the property, okay, it is the use of usufructuary which has the obligation to make them. How about with respect to extraordinary repairs? Article 593 tells us that extraordinary repair shall be at the expense of the owner. The use of usufructuary is obliged to notify the owner when the need for such repair is urgent. If the owner should make the extraordinary repairs, he shall have a right to demand of the use of usufructuary the legal interest on the amount expended for the time that the use of rock lasts. An example of an ordinary repair would be a broken doorknob. So if, for example, you are the use of usufructuary of a house and the knob was um, destroyed, okay, or due to normal wear and tear of the property, the knob got broken. So in that case, the duty to replace the knob belongs to the use of usufructuary. Okay, but if, for example, the roof of a house or the ceiling of a house was destroyed by termites, and there is a need to replace the ceilings, okay, the joist in the ceiling, then that would fall under extraordinary repairs, which is at the expense of the owner. Okay? So the payment of annual charges and taxes and those considered as a lien on the fruits shall be at the expense of the usufructuary for the time that the usufruct lasts. Remember, taxes on the fruits, okay, shall be shouldered by the usufructuary. Okay, the taxes which during the usufruct may be imposed directly on the capital shall be at the expense of the owner. Taxes on the capital should be paid by the naked owner. Taxes on the fruits should be paid by the usufructuary. So the expenses, costs, and liabilities in suits brought with regard to the usufruct shall be borne by the usufructuary. Okay? Only with respect to the usufruct, but if it is, for example, on the land or on the capital, it should be borne by the naked owner. Okay. Let us go to the other obligation. Article 598 tells us, if the usufruct be constituted on the whole of a patrimony, and if at the time of its constitution the owner has debts, the provisions of Article 758 and 759 relating to donation shall be applied both with respect to the maintenance of the usufruct and to the obligation of the usufructuary to pay such debts. Okay? So, when you say kasi a usufruct is constituted on the whole of the patrimony, meaning the entire property of a person. And if at the time of the constitution of the usufruct, there are debts, okay, debts of the naked owner. So, in this case, the with respect to the maintenance of the usufruct and the obligation to pay the debts, it will be governed by Articles 758 and 759 relating to donations. Okay, it may be reduced due to inofficiousness if it affected the compulsory legitimes of the heirs. Okay. Article 599, the usufructuary may claim any matured credits which form part of the usufruct if he has given or gives the proper security. If he has been excused from giving security or has not been able to give it, or if that given is not sufficient, he shall need the authorization of the owner or of the court in default thereof to collect such credits. Okay, so because there can also be usufruct with respect to matured credits. Okay. Article 600, the usufructuary of a mortgage immovable shall not be obliged to pay the debt of the security for the security of which the mortgage was constituted. Because there can be cases when a real property, for example, is subjected to a mortgage by the naked. But during the term of the mortgage, he also executed or granted usufruct in favor of another person. So in that case, the usufructuary is not obliged to pay the mortgage, to pay the loan which was secured by the mortgage. If the immovable be attached or sold judicially for the payment of the debt, the owner shall be liable to the usufructuary for whatever the latter may lose by reason thereof. Because there can be cases when the mortgage was foreclosed before the usufructuary ends. So in that case, if there, for example, there is still a period of 1 year before the expiration of the usufruct and the mortgage was already foreclosed, then it is the naked owner who will be liable for that remaining period to the usufruct. Okay? Another obligation of the usufructuary is to notify the naked owner of any act of third persons of which he may have knowledge that may be prejudicial to the rights of ownership, and he shall be liable, should he not do so, for damages as if they had been caused to his own fault. If, for example, he received notice that someone is squatting on the property, he should notify the naked owner of that intruder, okay, on said property. Also, the owner, being the one who has dominion over the property, may construct any works and make any improvements of which the immovable in usufruct is susceptible, or make new plantings if it be rural, provided that such acts do not cause a diminution in the value of the usufruct or prejudice the rights of the usufructuary. After all, he is still the naked owner. So he may make improvements thereon, even during the period of the usufruct, provided that it will not cause damage to the use or enjoyment of the property by the usufructuary. Okay, we now go to the summary of the obligations of the usufructuary. Of course, prior to the commencement of the usufruct, he has to conduct an inventory consisting of the appraisal of the movables and description of the condition of the immovables to give security, okay, in order to ensure the naked owner that he will perform his obligations, okay, to take care of the thing given in usufruct as a good father of the family, to answer for any damage caused by his fault or negligence or the person who substitutes him, to make ordinary repairs, to notify the owner if there is a need for extraordinary repairs, to pay legal interest on the amount expended by the owner for extraordinary repairs for the time that the usufruct lasts, to pay annual charges and taxes and those considered as lien on the fruits, to pay the expenses, costs, and liabilities in suits brought with regard to the usufruct, and to notify the owner of any act of third persons of which he may have knowledge which may be prejudicial to the rights of ownership. Okay, how does usufruct end? Okay, usufruct is extinguished by any of the following causes: by the death of the usufructuary, unless a contrary intention clearly appears. Example would be multiple usufruct. So the death of one of the multiple usufructuaries would not terminate the usufruct. In fact, his right would accrete to the other usufructuary. So in that case, death did not extinguish the usufruct. But if it is constituted only in favor of one person, the death of the usufructuary terminates the usufruct unless there is a contrary intention. Okay? By the expiration of the period for which it was constituted or by the fulfillment of any resolutory condition. So usufruct is always temporary. So it is either with a period or subject to a resolutory condition. The happening of that condition would result uh, um, in the end of the usufruct. Okay? By merger of the usufruct and ownership in the same person. So if the usufructuary became the owner or became also the naked owner of the property given in usufruct, then the usufruct will end. Okay? Because he will now be exercising the right to use and enjoy the fruits of the property, not as a usufructuary, but as an owner. Okay? By the renunciation of the usufructuary. So if he waives or renounces the usufruct, okay, total loss of the thing in usufruct, by the termination of the right of the person constituting the usufruct, like for example, in case of usufruct, which is subjected to a mortgage, if the mortgage was foreclosed and the property was sold, okay, and the usufruct still subsists, then the right of the usufructuary will also terminate without prejudice to whatever damages that the naked owner would be held liable for, and by prescription. So if the thing given in usufruct is lost only in part, the right shall continue on the remaining part. So a usufruct constituted in favor of several persons living at the time of its constitution shall not be extinguished until the death of the last survivor. That is what is called multiple usufruct. So until the last survivor is still living, then the usufruct will subsist. Okay? Usufruct cannot be constituted in favor of a town or corporation or association for more than 50 years. If it has been constituted and before the expiration of such period, the town is abandoned or the corporation is dissolved, the usufruct shall be extinguished by reason thereof. There is no such thing as a perpetual usufruct. It is always temporary in duration. So if it is constituted in favor of a juridical person, such as a corporation, the maximum period for the usufruct should be 50 years. It cannot exceed the said period. Okay? What if a usufruct is granted for the time that may elapse before a third person attains a certain age? Like for example, a usufruct is granted to X, which shall be effective for until he reaches the age of 50. Okay? It shall subsist for the number of years specified, even if the third person should die before the period expires. So if, for example, at the age of 35, X died, okay, it will continue for the remaining 15 years unless such usufruct has been expressly granted only in consideration of the existence of the person. So in such a case, if that person dies, the usufruct is also extinguished. Article 607, if the usufruct is constituted on immovable property of which a building forms part, and the latter should be destroyed in any manner, the usufructuary shall have a right to make use of the land and the materials. That is why in the cases which were previously discussed in the Albar, okay, even if the building was gutted by fire, the usufruct still subsists on the land as well as the material salvage from the fire. Article 609. If the thing in usufruct be expropriated for public use, the owner shall be obliged either to replace it with another thing of the same value and of similar conditions, or to pay the usufructuary the legal interest on the amount of the indemnity for the whole period of the usufruct. So we are speaking here of a situation where during the period of effectivity of the usufruct, the land was expropriated by the government. In such a case, if the landowner, if the naked owner has another property which is equivalent to the property in usufruct, then he may give the said property. If not, the legal interest for the period of the duration of the usufruct of the compensation for the said land should be given by the naked owner to the usufruct. Okay, because that will be considered as the fruit of the property in use. Okay, will bad use extinguish the usufruct? Remember, the naked owner, the usufructuary is entitled, is obligated to use the property with the diligence of a good father of the family. What if there is bad use on the part of the usufructuary? It will not extinguish the usufruct, but the usufructuary may be held liable for damages. Okay, the security that was given by the usufructuary can be held accountable for the damages that the thing in usufruct may suffer by reason of bad use. If the abuse should cause considerable injury to the owner, the latter may demand that the thing be delivered to him, binding himself to pay annually the usufructuary the net proceeds of the same after deducting the expenses and the compensation which may be allowed him for its administration. So the owner can demand the return of the thing, or he may demand damages from the security which is given by the usufructuary. Okay, Gaboya versus Smith. In this case, Don Mariano is the owner of 3 lots. Okay, he sold these 3 lots to his children. Okay, but retained for himself the usufruct of the property. Subsequently, a building was built on a portion of this lot at the expense of the children. The question is whether the usufruct reserved by the vendor in the deed of sale over the lots in question, which at that time were vacant and unoccupied, gave the usufructuary the right to receive the rentals of the building constructed by the vendors. So the reserved usufruct in favor of the vendor was limited to the rentals of the land alone. So the usufruct over the land did not entitle the usufructuary to either the gross or the net income of the building erected by the vendees, but only to the rental value of the portion of the land occupied by the structure. Because at the time when the deed of sale was executed, there was no building. Okay, it was the vendees who constructed the building. So there was a usufruct over the land. So the rental portion of the land should be the one to be given to the vendor and not the rental of the building. A usufructuary rights of the late Don Mariano reserved in the deed of sale was over the land alone and did not entitle him to the rents of the building later constructed thereon. Okay? The case of Baluran versus Navarro, this is a case involving a usufruct subject to a resolutory condition. Okay. Paraiso were the owners of a residential lot. They executed an agreement which they called barter. Okay, they agreed with the spouses Baluran, okay, to they allowed the spouses Baluran to use the residential lot. They provided that in the event that any of the children of Natividad chooses to reside in this municipality and build his house, the party of the second part shall be obliged to return the lot. So Evidencio filed the complaint to recover the said residential lot from Baluran. Okay, because he now needs the property, he will build a house on the said property. So with the material possession being the only one transferred, all that the properties acquired was the right of usufruct, which in essence is the right to enjoy the property of another. Thus, the mutual agreement, each party enjoying material possession of the other's property was subject to the resolutory condition, the happening of which would terminate the right of possession and use. So the manner of terminating or extinguishing the right of usufruct is primarily determined by the stipulations of the parties, which in this case is the happening of the event agreed upon. So the respondent in whose favor the resolutory condition was constituted took immediate steps to terminate the right of the petitioner. With the happening of the resolutory condition, the right of usufruct is extinguished and each is entitled to a return of his property. So the resolutory condition is when the time comes when the obencido, okay, needs the lot to construct a house thereon. Okay, once it happens, okay, the resolutory condition is fulfilled, the usufruct terminates. National Housing Authority versus Court of Appeals. This is also the Manila Seedling Bank case, wherein a presidential decree granted Manila Seedling Bank occupancy over usufruct over a 7-hectare portion of a prime property in Quezon City. A usufruct may be constituted for a specified terms and under such conditions as the parties may deem convenient. The NHA may not evict BGC if the 4,590 square meter portion MBSF leased to BGC is within the 7-hectare area held in Usufruct by MBSF. The owner of the property must respect the lease entered into by the usufructuary so long as the usufruct exists. Because MBSF here, Manila City Bank, is the usufructuary. And then BGC was the one leasing the usufruct. So it is very clear here. It is an illustration of the fact that the usufruct is transmissible. The usufructuary need not be the one to personally enjoy the property. He can lease it to another person. Article 605 clearly limits any usufruct constituted in favor of a corporation or association to 50 years. A usufruct is meant only is as a lifetime grant. Unlike a natural person, a corporation or association's lifetime may be extended indefinitely. The usufruct then perpetual. So in case of juridical persons, there is a limit to the period of the usufruct. It should not exceed 50 years. Okay? We now come to the last case, which is moralidad versus fairness. Again, like the previous case of Baluran, okay, it also deals with the usufruct subject to a resolutory condition. Now, in this case, the petitioner, okay, moralidad, acquired a property, okay, initially for the purpose of letting her niece Arlene use the property. Okay, she was working abroad at that time, but when she came back to the Philippines, she resided on the said house with her niece. However, their relationship turned sour. So, because of that, she filed a complaint to eject her niece Arlene from the said property. Okay. Use of rock is, in essence, is nothing else but simply allowing one to enjoy another's property. This also defined as the right to enjoy the property of another temporarily, including both the jus utendi and the jus provendi, with the owner retaining the jus disponendi or the power to alienate. So the document executed by the petitioner constitutes the title creating the use of rock. Okay? The occurrence of any of the following, the loss of atmosphere of cooperation, the bickering or the cessation of harmonious relationship between and among kin constitutes a resolutory condition, which by the express wish of the petitioner extinguishes the use of wrong. So in the document which granted her niece rights, usufructuary rights over the said property, moralidad provided a resolutory condition that if the harmonious relationship ends, then the use of rock is extinguished. The continuing animosity between the petitioner and the Pernes family and the violence and humiliation she was made to endure despite her advanced age and frail condition are enough factual basis to consider the use of rock as having been terminated. The relationship between the petitioner and the respondents respecting the property is one of owner and usufructuary. Respondents claim for reimbursement of the improvements they introduce on the property during the effectivity of the usufruct should be governed by the applicable statutory provisions and principles on usufruct. As usufructuary do not have the right to reimbursement for the improvements they may have introduced on the property. The respondents, however, may remove or destroy the improvements they may have introduced without damaging petitioner's property. So that is all for use of rock. Thank you for listening.